hearing anything else from you. I'm going to do what I got to do.
That's fine.
I'm just going to, no, do not talk. Stop.
I said I won't say anything else.
Just stop.
This hearing starts with tension already in the air. What looks like a routine procedural discussion quickly turns into a heated exchange between the judge and one of the parties in the case. The dispute revolves around evidence submissions, specifically, a flash drive containing video from a previous hearing, and whether both sides have properly received the materials. Now, in court, fairness requires that both parties have access to the same evidence before any decision can be made. If one side hasn't seen something the other submitted, the judge legally cannot move forward. But as this hearing unfolds, frustration starts to build, especially as the conversation becomes more emotional and less procedural. Watch closely, because what begins as a discussion about paperwork soon turns into a moment where the judge must reassert control over the courtroom.
You have something you're holding up. What are you trying to get?
I submitted to the court an answer to that, and I sent a copy to her. I don't know if she's received it or not yet.
Is that the response to defendant's objections and evidence submitted about January 15, 2024 hearing? That's what you, okay.
That's right.
All right. Have you received that?
I have not.
Okay, folks. All right. All right. Somewhere along the line, we've got to make sure, because it becomes impossible for me to conduct a hearing where one party has submitted something and the other party doesn't have it. And I'm not saying, I'm not blaming either party. I'm just saying that's the cold-hearted reality of where I end up.
Your Honor, may I say something?
How did you send this to Ms. Norman?
U.S. mail.
Okay, well,
you know,
that's going to be.
I thought our hearing was a little later in the month. I thought she was going to get it, and I just got the notice about our hearing date yesterday. So I was thinking maybe I should.
Well, that maybe should tell you something about the mail. All right. Here's what I'm going to do. I think we have Miss Norman's email, right?
Yes, sir.
Okay. So, folks, they're not sure that. Yes,
Can I say something, please?
Yes, go ahead.
That video from the hearing from 10/22 of 2024 has on there where Mr. Stanford waived his right to monetary damage and rent because of the case, and my case being I dismissed my case in order to come to that end. So I don't know. I just feel like at this point, it's, we're just on the court's time and we're wasting it with,
well,
all of these things.
Ms. Norman, I understand what your position may be. My position is that if somebody submits something to the court, I have to at least look at it and consider it. The very fact, I don't think, if you think about the last hearing, you submitted something and I didn't get it because of whatever the circumstances were. I didn't have it. I don't think you would want me to proceed without having that. Mr. Stanford has submitted something. I'm not going to have a problem going through it. You just have to have it so that you can respond to it if necessary, because you're entitled to have it. Here's what I'm going to do. At this point, there'll be no additional filings. All right? Because I don't want to end up in this circumstance. We have Ms. Norman's email?
Yes, sir.
All right. So what I'm going to do to expedite the process, Ms. Norman, because normally I'd put it out however long it may take the mail to get there. I'm going to have my staff copy what Mr. Stanford has submitted, email it to you so that you have it. Okay? So
what happens then? He's got an answer to the video, and then I see something on his answer but yet I can't
Then
answer.
you guys can argue that before me. Miss Norman, I can't force this to go any different.
I don't
If
want
I
to
could-
argue. I want it to end. I want it to end. And this is just how we were in October of 2024. Frustrating you.
So I am not frustrated. I'm frustrated by your failure to
I'm not a failure.
permit the court to
I'm not a
proceed
failure.
with how it has to proceed. I just explained to you why I can't do it the way you want me to do it.
Because he submitted an answer. Is that correct?
What did I just tell you, Miss Norman? What did I just tell you?
Sir, I've been in this courtroom almost probably 13 times now. It's very frustrating for me. I'm not a failure. I'm doing everything that I can to end this court case.
Miss
He has-
Norman, I'm
I'm
going to
just-
tell you this, and then I'm not hearing anything else from you. I'm going to do what I got to do.
That's fine.
I'm just
That's
going to,
fine.
no, do not talk. Stop.
I said I won't say anything else.
Stop. Just stop.
That's how you treated me in October of 2024 as well.
I'm done. Then here's what we're going to do. We're not sending it. She'll wait for the mail. I'll just adjourn this case out. Where are we adjourning it? Yep. We'll just put it out so she can get the mail. I'm going to do it that way. I was trying to expedite it for her, but she's going to treat me rudely. It's not going to
Don't
happen that
treat
way.
me rudely.
Give
I'm
me a
very
date. I'm
respectful.
done. Mute her because I'm done with you.
March 10th.
March 10th. I'm adjourning this to March 10th, 2026, 9 a.m. Thank you. You can kick her out.
What started as a simple procedural issue quickly escalated into a moment about courtroom decorum and authority. The judge initially tried to help move the case along faster by emailing the evidence directly instead of waiting for traditional mail. But when the discussion became argumentative and the interruptions continued, the judge made it clear that the courtroom would proceed on the court's terms, not anyone else's. Legally speaking, judges must ensure fairness between both parties. That means if one side submits evidence, the other side must have time to review it before the hearing continues. Instead of rushing the process, the judge ultimately decided to adjourn the case to a later date, allowing time for the evidence to be delivered properly through the mail. Moments like this highlight an important rule in court: respect and procedure matter just as much as the evidence itself. Now we want to hear from you. Do you think the judge handled the situation the right way, or should the hearing have continued despite the disagreement? If you found this courtroom moment as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.